Wonderful. I am delighted to be here. Again, Michael Roosevelt, Senior Court Service Analyst with the Criminal Justice Services. Well, why are we doing this broadcast, Judicial Council? We think it's important that courts come together from time to time to discuss important and critical issues that relate directly to their work. The Lunchbox series is an attempt to have an ongoing conversation about what we can do to better understand what the research says and what are the best practices when it comes to adult drug courts. We call this Adult Drug Court Lunchbox, but it's for everyone and anyone, for drug courts, non-drug courts, or any other type of collaborative courts. We hope, following this broadcast webinar, you'll have an opportunity to kick off ongoing and continuing discussions among your team members about the drug court adult standards. So we are delighted that you are able to join us. I'm particularly delighted to welcome our speaker for today, Terrence D. Walton. Terrence D. Walton is Chief Operating Officer for the National Association of Drug Court Professionals, or NADCP. He is among the nation's leading experts in providing training and technical assistance to drug courts and other problem-solving courts. Prior to being named COO in October 2015, Terrence was the NADCP Chief of Standards. He retains his responsibility for establishing and implementing best practices of the standards nationwide. Welcome, Terrence.
Thank you so much, Michael, and also thank you, Octavio, and thank you for everyone so many of you who have joined this webinar today. This is, folks, one of the premier topics across the collaborative court, treatment court, drug court field today. States and individual jurisdictions and individual practitioners are reaching out to our offices asking for help, especially once they've identified that they have some issues, some problems related to equity or inclusion in their court, or in some cases, if they have no idea. And they begin to recognize, based on what they're seeing from our reporting and other sources, that in some drug courts across the country, there do appear to be differences in the percentages of the numbers of African Americans, Hispanics, or Latinos who are getting into the courts, and in some cases, differences in how successful they are when compared to non-minorities. So it's an important topic, and we're encouraged here at the office to have so much interest, including the interest from the state of California, who asked us not just to do some stuff on site, but also to offer this webinar so more of you could join this discussion. So this is, this is a presentation which sometimes is done in 3 hours, sometimes in 1 hour and 15 minutes. We'll do it in even less, because I do want to leave at least 10 minutes or so at the end for you to ask any questions that you have. As has already been mentioned, if you have any questions as you go along, use your chat feature and go ahead and send that. Don't wait till the end to send it. Please chat your question in as soon as you have it. That will allow the host, when we get to the Q&A period, the host to go right to questions and not have us waste any time. So this presentation really is about making two really big points, with the first point being that as a practitioner in a collaborative court, no matter where you are, that drug court professionals have an affirmative obligation to know how everyone is doing in their program, and especially individuals who have traditionally either faced discrimination or somehow been underserved in the justice system. So it's an obligation. So that's the first big point, that we have an obligation to know, and that not knowing in itself, not knowing how many African Americans, Latinos, Hispanics, or women that I have in my program compared to what's in the arrestee pool or whatever pool of drug court eligible folks there are, not knowing that comparison, not knowing the proportion and whether it looks like if we've got about 25% of our drug court eligible pool is African American, yet we only have 15% in the program. Not knowing whether that is the case is in itself being out of adherence with this important principle. So that's the one big point. And the second big point is, don't be afraid to know. If you see that there is a problem, if you know that there is a problem, then that simply means let's figure out what that's about. Many times, there are really innocent reasons and sometimes easily fixable reasons that explain the discrepancies. Not always, but sometimes. So 2 big points: you got to know, don't be afraid to know, and take action to try and address it. Back in 2010, the National Association of Drug Court Professionals Board of Directors issued the resolution that you see on your screen. And I, of course, am not going to read it all. But the slide you're seeing here really makes the case for why this matters. It makes the case about the issues we know that relate to the justice system in general, about its impact on people of color in general. And it also makes a really important point that drug courts, and as you call collaborative courts, have been credited, I think correctly, with helping to alleviate some of the unfair disparities in incarceration rates from people who are part of racial and ethnic minority groups, especially as it relates to drug-related offenses. There's a lot of talk today, about justice reform and trying to reverse some of the unintended harms of the war on drugs. But the reality is that even 7 years ago, in 2010, we believed that drug courts need to be on top of this issue. And frankly, back in 1989, when the first drug court was open, part of the intention was to be sure that the war on drugs didn't have casualties, and that people who were in the justice system primarily because of their addiction or mental illness had a fighting chance. So we're not new to this game, that we're not new to the effort to be sure that people are treated fairly, and that racial and ethnic minorities in particular aren't treated more harshly in the justice system. That's part of why we exist. But as we have had now, I guess 27, 28 years of existence, we see a lot of good things. We see that many drug courts are serving their populations as they come to them, and that when we look carefully at the data, there are no discrepancies in either who's getting in drug court and no discrepancies in who's getting out of drug court successfully. That's the case in many drug courts, but not all. And we'll talk more about especially that not all population as we roll forward today. The second part of the resolution says this is what you got to do. It makes it sort of resolves that we have an obligation to know. And it talks about the kinds of things we need to know. I'll review those as we go over the adult drug court best practice standards on this topic. And then it also says that knowing is not enough. That knowing also means we're going to, as a team, under the leadership of a judge who believes in this and who is taking responsibility, and a prosecutor who believes in this and is going to take responsibility for it, we're going to take some actions to try and be sure that we are giving everyone a fair shake of getting in and doing well. So I urge you to go to our website at allrise.org. There's a section for the board and board resolutions, and read this resolution in its entirety, but most of it is available for you in the PowerPoint there. So in 2013, I know that everybody on this call is aware that we released the adult drug court best practice standards, and I am happy that I am via webinar, so that if I take a poll to say how many of you know that these standards exist, if any hands don't go up, I wouldn't see it. So sometimes in big state conferences, I've asked that question, and not every hand goes up. So I'm going to assume that everyone on this call knows that the Adult Drug Court Best Practice Standards exist. We released Volume 1 in 2013, and then Volume 2 a couple years later. They're all available to you free of charge. Just go to allrise.org, type standards. Both versions will come up as PDFs that you can download. We'll also have at our national conference this year, July 9 through 12, we're doing a big reprinting of both volumes, so people who want, a physical copy, a bound book copy, can get that at the national conference. Well, in Volume 1, the first standard in Volume 1 is target population. That's the standard that says the drug courts are a great thing, and drug courts work, but not all the time, and not for everybody. And so the first standard makes the point that for drug courts to be effective, they need to be servicing the right people, servicing, treating, and supervising people who need that level of attention. And if people don't need that level of attention, we encourage alternatives for that population, either an alternative track within the drug court, within the collaborative court that has different requirements, or a separate option altogether. So that's the first standard, which is kind of where it all begins. But right after that, we follow with the standard that is now titled Historically Disadvantaged Groups. And that, we didn't wait till the end to put that in. We put that right at the beginning because it says, now once you've established the right target population, be sure that everyone who meets that target population has the equal opportunity to access your court and the equal opportunity to be successful. And you're urged to look specifically, and you want to know this for everybody. You want to know how everyone's doing, but you want to pay special attention to subgroups within your population. And in this case, we've listed groups who have historically experienced discrimination for you to pay attention to in a special way, not just get them wrapped up into your overall numbers, but pull out a subset to be sure that people, regardless of race or ethnicity or gender or other factors, are getting an equal opportunity, at least it looks like they're getting an equal opportunity to get in and do well. Now, I should pause here because if you have your standards in front of you, the standard is titled, as I mentioned, Historically Disadvantaged Groups. And I'm describing it here as equity and inclusion. You are among the first to know in the country that when we reprint the standards this summer, we are changing the title of Standard 2 from Historically Disadvantaged Groups to Equity and Inclusion. We're doing that for a couple of reasons. We got a ton of feedback from individuals who spend a lot of time on issues of equity and on issues of equal access. We got a ton of feedback after the peer review process, after we'd already published, indicating that while the term historically disadvantaged groups was very popular at one time and certainly makes a point about the population you're looking at, but that term itself is disempowering, and it sort of muddies over the real issue and chooses a sort of deficit-based term to refer to a group of people. And so rather than try to figure out another way to say that, we decided to rename this standard to really describe what we hope for in drug court, and that is equity and inclusion. So you're the first to hear about that change. We have to peer review the change itself, so it's possible the title might be slightly different, but that's why I've already started training using the new title, starting with this webinar today. So really quickly, you see there the description of the people that we're the subset of your overall population. The drug courts all across America are now being sure they're collecting data and analyzing data concerning. These are folks, individuals who have historically experienced sustained discrimination or reduced social opportunities because of their race, ethnicity, gender, sexual orientation, sexual identity, physical or mental disability, religion, or socioeconomic status. We want to ensure that they receive the same opportunities as other individuals to participate and succeed in drug court. We listed a lot of categories there. I'll tell you in a moment why, despite the fact that we make this global statement that we really want everyone treated fairly, that we focus primarily, or in some ways, I guess exclusively, on race, ethnicity, and gender in this standard. I'll tell you why in just a moment. But for now, this is the overall statement that says here's the principle that should govern drug courts as it relates to this issue. The standard is divided into the 6 areas you see there, and I want to say very briefly what that's about, because it sort of is our marching orders. If you're trying to figure out, okay, I want to collect data, or I want to, I need to know what really matters when it comes to equity, and inclusion, and that is these 6 things. It says, first of all, that people need to have equivalent access. So you compare numbers, as I mentioned before. You compare who you have to who you could have. You look at, you know the racial, ethnic, and gender distribution in your collaborative court right now or traditionally over time. You compare that as best you can to those same factors in whatever your drug court potential pool is, whether that be people arrested with charges that are likely to be drug-related, whether it's people on probation who are testing positive, whatever you determine is the best, pool you can compare it to. We compare it to national numbers. We look at what happens nationally, the numbers of people who get in drug court, the percentage of folks in drug courts nationally compared to national arrestee rates. As you get closer and closer to the programmatic side, you want to look at national rates, absolutely, but you want to try and look at something much closer to your world for comparison. So the first question is, are all people having equal opportunities to get in our program based on looking at who's in the program? Secondly, you want to say, are people being retained at similar rates? Drug courts generally have retention rates, people who finish the program successfully, of anywhere between 40 and 60%, sometimes more, sometimes less. And you want to know your overall retention rate, but also you want to pull out certain subgroups like people of color, racial and ethnic minorities, as well as women, and look at their numbers in comparison to everyone else to see if it looks like the people are finishing successfully in similar rates. And you also want to look at the treatment that's delivered, the providers that are being used, the treatment centers people are going to, the levels of care, whether it's residential treatment or treatment that involves medications or intensive treatment as opposed to regular outpatient. You want to look at the quality of treatment that's received in your program and then compare it to be sure that, whether it's inadvertent or not, that certain people appear to be getting a lower quality of treatment than others. And you also want to look at equivalent incentives and sanctions. You want to look at whether or not individuals who, that you want to look at basically who you're sanctioning, how often people are being sanctioned, how quickly people are being sanctioned to involve jail sanctions, and then compare that and see if, at least just on raw numbers, it looks like it's equivalent or not. And then finally, the recommendation is that, or the guidance is that you pay attention to what happens when people finish drug court. When people finish successfully, are they equally being offered the same kinds of dispositions? So if two individuals are similarly situated, and one is a individual who has historically experienced discrimination and one is not, on average, are they getting equivalent dispositions? This is equally important when we look at those who finish unsuccessfully. There are some programs where not finishing a collaborative court successfully might end up with an augmented sentence or some more adverse outcome. This standard doesn't address whether that's a good idea or not. But this standard says that whatever you're doing, when you look at the data, it should look like things are happening fairly regardless of race, ethnicity, or gender. I will say that as we'll look at, the best research and reporting we have indicate problems in some drug courts as it relates to item A and B. That we don't see clear evidence that there are disparities when it relates to C, D, and E. It doesn't mean those don't exist, but we don't see strong evidence of that yet. Despite that, these are such important issues as it relates to what a collaborative court of any kind is supposed to do. You need to focus on C, D, and E in addition to A and B, just to be sure there's not a problem in your court. Because keep in mind, whenever we do research and report it in the aggregate, we're reporting averages. So even though on average it looks like things are okay in C, D, and E, that does not mean that there aren't some programs where that was a problem. And so we encourage all of these areas to be looked into. And then finally, it says team training, that you really want to be sure that the entire team is being regularly trained to be sure of a couple things, to be sure that they are aware of the biases, often the hidden biases unknown to even ourselves that all people have, and how to be sure that's not adversely affecting your decisions, and also to be sure that you are providing culturally competent services and supervision and treatment. And so that's what the standard says. Please read it on your own for more details. So a question that sometimes comes up is a couple things. It's first of all, why are we focusing on racial and ethnic minorities? Partly as opposed to all the other groups that are referenced here. We talk about people needing to be treated fairly, regardless of sexual orientation, identity, disability, religion, and so on. Yet the standard, as it is fleshed out, it only focuses on race, ethnicity, and gender. And that's for a couple reasons. First of all, it's because that is the area, those are the categories that are most easily observable. It's easy to know gender, race, and ethnicity by simply observing and asking the question without being too intrusive. Now, if you know of other categories, and you can know so without requiring people to disclose things which aren't critical, then look at those other areas as well. But when it comes to race, ethnicity, and gender, an observation and asking people how they identify can make it easy to determine whether a person fits in one category or the other. It's also because these are the areas, especially when it relates to race and ethnicity, but also gender to a lesser degree, that's where the research is. That's where we know, based on some of our data analysis and other research, that's where there have been problems in the justice system in general, and in some cases as it relates to drug courts. And then finally, the reason for the focus on racial and ethnic minorities is because they are a part of what I think is a really unfortunate term, but it is the legal term, and that is they're part of constitutionally suspect classes. And those really is another way of saying these are individuals that, based on the history in this country, have likely had their constitutional rights violated based on their race, ethnicity, or gender. And I see a typo there that we'll fix, and it's going to bother me if I don't mention it. Y'all see it too. It's not ethnic minorities, it's ethnic minorities. We're sorry about that. Spell check wouldn't catch that, but we'll correct that the next time we do this. So we have a constitutional obligation because drug court is a privilege. Drug court, unlike most aspects in the criminal justice system, drug court is a benefit. And while in most parts of the justice system, when people talk about the problem is racial and ethnic minorities being overrepresented in jails and prison, and overrepresented on probation, supervised probation. In drug courts, the problem is underrepresentation. Because these men and women are already in the justice system, we want to see them having an equal opportunity to have the benefit of getting the kind of quality treatment and the kind of good outcomes you get when you are placed correctly in a treatment court of some kind. And even I'll talk some about intent versus impact, whether people intend to do harm. And the reality is, even if unintended discrimination may not be a constitutional violation, it is still contrary to treatment court best practices, that we have a higher standard than just what is constitutionally, objectionable because of what we stand for. So let me just take a second and talk about intent versus impact, so that we don't lose ourselves in justifying our actions and struggling with guilt over, well, we didn't intend to do harm, and if our program is showing problems, does that mean that we have been deliberately trying to harm people and that we are racist and discriminating? This doesn't say that at all. It doesn't assume that there are problems, first of all, because for some of you, there are not going to be problems when you look at it. It doesn't assume that there are problems, and it doesn't assume that if there are problems, that signifies that people intended to discriminate. Now, sometimes that is the case, but not usually. And there's nothing in this standard which requires us to assume ill intention, and so we don't. What really matters here, though, is the impact. The intention matters as it relates to what's legal or illegal, what's constitutional versus what's unconstitutional. But that's a tiny part of what matters most here. What matters most here is impact. And despite my intentions, if my actions, if our policies, if our screening criteria, if the way we screen, if the process we use to make decisions about who gets in and who gets kicked out, if any of that appears to be harsh or have a more adverse impact on racial ethnic minorities and women or others, then that's what matters. It turns out that for good reasons, we put together certain criminal history disqualifiers. If the impact of some of that means that people who are, the charges that and convictions that people of color traditionally have are excluded, then that wasn't intended to be harmful, but the impact may be harmful. And so this standard says, don't get lost in trying to justify my intention. Focus on the impact of our decisions, the impact of our processes, the impact of our policies and procedures, regardless of what the intention was. When I'm in a room with people and when we are on webinars engaging in discussion, if we don't get lost in intent and instead focus on impact, it's much more productive and much more likely to result in actual changes. So the standard says you got to know if there are disparities, and that is not, and that's, it's easy for me to say those words, and it's only 4 words, so it's easy to type it on this slide, but that sometimes is a task in itself. Sometimes figuring out, who you have, but especially who you could have, can be complicated. You got to find a pool to consider. You have to figure out who is the gatekeeper and have to know kind of who was presented to, who was considered for inclusion and who wasn't considered, and who was offered and refused. And there's a ton of questions that come up that the teams have to work through to get the best data they can. Because it's hard to find the comparison group, because it's hard, that does not absolve us of the responsibility to be sure we figure out if disparities exist. Our office is available to help with that process, to help you explore ways of doing that, find the best comparisons you can, but you do need to know if disparities exist in your program. And this matters because most of the standards, the other 9 standards, say that you need to have a well-run program. It kind of says you need to have a great program. You want to work toward that. This standard doesn't say that. This standard does not say your program has to be A1. But what it does say that even if your program is crappy, it needs to be equally crappy for all. That's what this standard is about. So disparities matter. And then it says, well, in the process, especially if you find disparities, then you want to, first of all, determine, okay, are we making admission decisions or placement decisions in a valid way? Are we delivering treatment that is evidence-based and culturally responsive? Have the interventions that we use in the treatment arena, have they been tested and researched on African Americans, Latinos, Hispanics, women? You want to ask yourself those questions, and you're especially going to ask those questions if you find disparities in like successful completion, or if you find that we tend to have to ratchet up the sanctions higher for certain groups compared to others. So that's part of this process. You want to look at the ways you make decisions and the kinds of services you deliver to be sure are they culturally responsive. It's the main reason why teams end up asking for training in these areas. You know, we are funded already to provide free training in these areas, and usually a team and sometimes a whole state ask for trainings in this area because they aren't sure if they're being culturally responsive or they've discovered they're not. And then it's simple. You know, as a team, work together, consulting with people on the team as well as people outside the team, defense attorneys and prosecutors and community advocates and others and participants themselves or potential participants themselves to get a sense of what might explain our discrepancy. Sometimes the discrepancy is about something that isn't directly related to race or ethnicity. For instance, when some of the research that's been done has been studied more carefully, the big difference here is that in certain communities, based on social economic status, the quality of treatment, the job opportunities, the educational attainment is lower, and people are less likely to succeed. That sometimes explains it. Now, if that is the explanation, it doesn't mean, okay, great, okay, let's go back to business as usual. It then still says, okay, what do we need to be doing to address that issue to be sure people have a fairer chance in our program despite their socioeconomic status? Other times, though, even when you control for socioeconomic differences, you still see disparities. And that suggests something different, not necessarily something sinister or intentional, but something that is somehow, despite socioeconomic differences, adversely impacting inclusion or equity among these particular groups. And then, you know, work together to put a plan together based on the best minds you can have to think this through, and then evaluate that plan. And then again, be sure that you're trained regularly. That's what the standard says. Read it more on your own. So there is a need to know, all right? We just released our latest Painting the Current Picture survey. This is a survey of all the problem-solving courts in the U.S. We survey state coordinators, and they survey individual programs and give us compiled results on lots of topics. If you don't have this, I urge you to go to our website, allrise.org, type in Painting the Current Picture. It's actually on the home screen right now, and you can download a copy. It covers every area imaginable in drug court, including issues that relate to equity and inclusion. And here's sort of the skinny on what we found. This, by the way, is based on reporting as of December 31st, 2014. We're always a couple years behind when we collect and analyze all this data and when we report on it. So here is sort of the big findings in this area. We find that on average, Caucasians represent about 67% of participants in treatment courts nationwide. African Americans represent about 17%, and Hispanics represent about 10%. Now, if we were comparing who gets in drug court, so 67% Caucasian, 17% African American, 10% Hispanic. If we were comparing who gets in drug court to the overall population numbers, this wouldn't be a huge concern, especially for African Americans. Now, it would still be a concern for Hispanics because they are greater than 10% of the population, but that wouldn't be the thing that led to the most concern, and it's not the best comparison. You really want to compare at least who's in your program to arrestees in your jurisdiction who appear to be drug court eligible based on criminal history, charges, drug tests, or something else. And when we did that, when state coordinators did that and reported back, we found indeed that African Americans and Hispanics, that their representation in drug court was lower than the arrestee, than the probation. It was lower than their percentages in the arrestee, probation, and jailed populations. Now again, the numbers were all over the place. There were some drug courts that were 98% minority, and some that were 0%, many in the middle. So within these numbers, there's some programs that had no problems, some programs that had big problems, some programs that African Americans did better than everybody else. It's all over the place, but on average, we saw issues of disparity that were at statistically significant numbers. When we looked at this is about inclusion. When we looked at successful completion, we found that African Americans and Hispanic participants completed drug courts at rates substantially below those of other participants. We saw that in the 2011 survey, and we saw it again in this survey. And there are also other research outside of the Painting the Current Picture survey, research that is more controlled that show the same thing. As it relates to women, we find that women represent about 32% of the drug court population, and that is at least proportional to their representation in probation, jail, and arrestee population. In fact, it's a little over. So there does not appear to be a problem with access for women in drug courts when we compare it to that potential pool. However, as it relates to successful completion of drug court, successful graduation, women graduate at rates that are below those of their male counterparts, at least on average. So if the question is, that's interesting to know nationally, but it says nothing about what's happening in California. And it definitely says nothing about what's happening in your drug court, in your collaborative court in California. So you got to know for yourself. You have to look at your own data to even see whether you might have a problem. If you conclude you do not, great. Just be sure the team keeps getting trained and then focus on other areas. If you do have a problem, or you might have a problem just based on the data, then you've got work ahead of you to figure out what that's about and to correct it as best you can. So, listen, I wish we had from this office, or I wish people across the country who are responsible for drug courts and across the state, I wish they had the ability to force people to look. But that's usually not the case. So it's a decision you make to look. And here's some reasons why some courts don't look. Sometimes they think they don't have any diversity. They think that these don't exist in their population. And unless you have a one-gender program, then you do have some diversity. And you want to be sure you're looking at everyone and being sure that you're not missing individuals, for instance, women and others who you should study. And even if you have a very few, you may not be able to draw big sweeping conclusions, but at least you can focus on the small numbers of minorities you have in your program to see how they're doing. Sometimes people say, well, we know we treat everyone the same. Well, you don't know that unless you look at the data, and that doesn't always tell you, but sometimes it does. And also sometimes treating everyone the same actually isn't appropriate. Equivalent doesn't mean exactly the same. Sometimes in order to be responsive and get success from certain populations, you're going to give them different kinds of services or focus on different areas. So treating everyone the same, A, may not be true, and B, may not be something you should be bragging about, because we know that is not how you get the best outcomes. Sometimes people believe that issues of discrimination are no longer relevant. We don't have to argue about that. Look at your data. Your data will tell you whether it's relevant, not anything else. Sometimes people say we don't have the data. Well, we get that. We didn't have the data here for a long time until we started asking the questions and compiling the data. The data is tough, it's hard, but especially as it relates to race, ethnicity, and gender, it's very knowable. And then you do the best you can to find a way to compare who you have to who you could have. And finally, sometimes folks get concerned, if we find something, what can we do about it? Well, that's the next question. What do we do about it? Folks, sometimes it's not complicated. Sometimes it's about, okay, we have some criminal history disqualifiers that there's no law that makes us have, that may be blocking out people who need the program. It might be that we have some process we use that's not valid. Maybe we figure out that we've got our criteria, but we also have this other piece where we determine whether or not a person seems right for the program. I'm almost out of time, but let me just give you one quick example, and it wasn't in California, all right? I had a court who was very concerned about this issue. They had noticed that over time, their program became less and less black. They were in a city that had a large black population and an even larger black population in their jails and prisons. And they were concerned. They brought us in to ask these questions. So as a part of the process, we looked at their eligibility criteria. We looked at their official screening process. We looked at lots of things, and we weren't seeing anything that raised a red flag. And ultimately asked them, well, just talk me through the process. You have a person in front of you or their file in front of you who might get in. Tell me how that decision is made. And everything seemed fine until some brave person who probably got chastised later said, and then the coordinator always has a picture, like either the mug shot or some picture they took for supervision, and we pass it around. And sometimes maybe someone knows this person and has reason to believe they're not going to be successful, or maybe they'll see a mark or a tattoo that suggests like gang involvement. And occasionally, the judge in particular could sort of tell by the person's expression, by their sort of scowl on their face, that they weren't serious. And sometimes that person was not allowed in. Folks, I'm not making that up. Again, wasn't in California, but that's an extreme example of like something that is probably explaining, the disparity in the program. So there are lots of ways to look at it, and lots of good minds, and we can help with that process, and people there in California can help you think through this if you find something. We are compiling solutions that courts have found. We're publishing some of that. We'll be offering several sessions at our conference to help people who find problems. So I want to end with this, and then I'll leave some open for questions. you want to really look at your program. I've provided several slides that I won't go over that advise you, like, on questions you should ask as it relates to data collection. I've got several questions here that help you that will guide you as you look at issues about our data. We also have specific questions you should be answering about, well, has our team been trained on cultural competence issues and diversity issues and inherent bias and that kind of stuff? You know, and in this particular example, it talks about at least every 3 years to cover staff turnover. There has been some evidence that this is important for helping people to deliver competent, culturally competent care. So look at those questions. We have questions here about your staffing patterns for you to look at and compare your the racial and ethnic and gender makeup of your staff compared to the population you serve, and other issues related to staffing. We've also encouraged you to look at your performance, to look at your activities, which organizations you have linkages with, how contracts are awarded and overseen, how your mission reflects your commitment to this issue or not, and several other areas that relate to performance patterns. We have advice here. I encourage you to look at those and consider following those steps, answering those questions as you assess, do we have problems in this area? There are lots of them there. The last thing I'll mention really quickly is there is something called an equity assessment, and this is something that are sometimes done at like a statewide level, where prior to making any program change, any change to program or services or policies, that the decision makers will be required to assess the potential impact on communities of color or other protected populations to determine what might be that impact. What are the populations that may be impacted? What are some of the positive impacts that might occur, as well as some of the negative impacts? We encourage programs that are considering changes. We encourage programs that are putting new policies in place to determine, you know, before they finalize, to go through a process to at least ask the questions, might this have some impacts on populations that have historically been underserved and discriminated against, and let's explore those. That might influence what you decide in particular. So the last thing I want to encourage you all to do is to copy down that link, or, you know, when you get the PowerPoint, click on it. And this is a test that it comes out of Harvard. It's something you do on your own. It's just for you, and it helps to identify hidden bias. You know, I have done this test more than once and have found that even though I am an African-American man who have always been an African-American man who had African-American parents and siblings, I found that I had hidden bias against my own people, and that's not easy to face. But I'm going to share that with you because I trust you. I encourage you to take this test on your own. It's free of charge. It sometimes is eye-opening and helps us to not be so sure that we, in our own practices, are operating free of bias. All right, so there you got to know, folks, when it comes to groups that have historically faced discrimination, you got to know who you have, know how they're doing. You see a problem, put a plan in place to correct that problem. Hopefully you can fix it, you know, but be sure you did fix it. And if not, go back to the drawing board, get some more voices in the table, you know, around the table, see if you can figure it out. All right, so there's a list of resources that I know y'all gonna look at every one of them to get more details on this, but at least read the standard on this, Standard 2 in Volume 1, and you'll be well on your way. All right, y'all, that was my lunchtime version of a really complicated presentation. Thank you for your attention. I'll now hand it back over to the host for a couple minutes of questions and answers.
Thank you so much, Terrence, for a wonderful presentation and very enlightening, and I think it'll give us all food for thought moving forward. I also encourage teams to take this presentation back to their teams to have discussions about inclusion and equity, and if they're already having that discussion, to continue having that discussion over the long term. We have not received any questions, and that's okay. We are delightful that people were able to join this call. I want to encourage you to make sure that you complete the evaluation. That's very important for us in order to improve our program, delivery of our program, and the content. We really look forward to having you join us for Standard 3, Roles and Responsibility of the Judge. Although we'll be talking about the role and responsibility of the judge, it is open to all members of your court team because it's the beginning of a conversation to think about what the role of the judge. That will be Tuesday, March 14th, 2017 from 12:15 to 12:45 p.m. This webinar will feature the Honorable Judge Desiree Bruce Lyle, Superior Court of San Diego. So we'll be really delighted to have her as part of this conversation. Thank you this afternoon for joining us. We look forward to having you participate in the future.